At the very heart of any constitution, there's this incredible, almost hidden tension. It's a conflict between the power that creates the Constitution and the power that's allowed to change it. Today, we're diving deep into this exact conflict, the battle between constituent power and amending power. It's an epic clash of ideas that actually gave birth to one of the most important legal principles in India, the basic structure doctrine. So let's unpack the logic that stops a government from, rewriting the very soul of a nation's law.
And that really brings us to the ultimate question, doesn't it? Can a government, which is only elected for a few years, use its power to amend the Constitution to change its most fundamental identity? I mean, can it alter the rules so completely that the original document is just unrecognizable? Believe me, this is not just some academic debate. This is a real-world battle that has defined the absolute limits of political power in courtrooms all across the globe.
All right, so here's how we're going to tackle this. First, we'll explore where a law's authority even comes from. Then, we'll get crystal clear on our two key players, constituent power and amending power. After that, you'll see how the showdown between them leads directly to the basic structure doctrine. And finally, we'll see how this whole drama played out in the incredibly high-stakes constitutional debates right here in India.
Okay, first things first. Before we can even talk about who gets to change a law, we have to ask a more basic question. Why do we follow laws at all? Where does their power over us come from? Well, the legal scholar Dietrich suggests that a law's legitimacy, its very authority, really flows from one of two fundamental sources. So according to Conrad, you've got two paths. On one hand, you have authorship. This is the active, powerful idea that a law is legitimate because we, the people, actually took part in making it. Think of it like a social contract we all signed. On the other hand, you have adherence, which is more passive. It's basically just accepting the system that's already in place. Now, while history is full of adherence, the modern idea of a constitution is fundamentally an act of authorship.
This whole idea leads us straight to what Thomas Hobbes famously wrote: "Authority, not truth, makes law." What he meant was, a law isn't valid because it's right or wise. It's valid because the power that created it was legitimate. And in a modern democracy, that ultimate authority, that authorship, is understood to come from one place and one place only: the people.
And that brings us directly to our first huge concept, which is the purest expression of that popular authority. We're talking about constituent power. So what exactly is constituent power? Think of it as the raw, original, untamed power of a people to decide their own political future, to give themselves a form of government. The most crucial part? It exists before the Constitution. It's not bound by any prior laws because it's the very power that creates the entire legal system from scratch. It's the architect of the state.
Now let's put that ultimate authority in sharp contrast with the tool that's designed for, let's say, everyday maintenance, the amending power.
Okay, so the amending power is totally different. It doesn't exist outside the Constitution. It's a product of the Constitution. Its authority is delegated, it's borrowed. Its job is not demolition, it's maintenance. It's there so the system can evolve and adapt over time without needing a revolution every time something needs to be updated. If constituent power is the architect, amending power is the renovator.
And right here, this is where we get to the core of the conflict. What happens when the creation, this limited amending power, tries to get bigger than its britches and challenge the will of the original creator?
It all boils down to this one simple, incredibly logical principle. A power that was established by the Constitution cannot possibly be used to destroy the fundamental nature of that very same Constitution. It just doesn't make sense. The amending power is a servant of the Constitution, never its master. To say otherwise would be like saying a branch can chop down the very tree it grew from.
Let's just put this side by side. It makes it so clear. The source of constituent power, the people. For amending power, the Constitution itself. The nature of one is original and unlimited. The other is derived and limited. And that directly defines their function. One is the architect, responsible for creation. The other is the renovator, responsible for adaptation. This single distinction right here is the key to everything else we're going to talk about.
So, if the amending power has these built-in limits, how in the world do you enforce them? This is where all that theory smashes into legal reality, and it takes the form of the basic structure doctrine.
The basic structure doctrine is, for all intents and purposes, the judiciary's tool to enforce that creator versus creation principle. It is the legal shield that protects the Constitution's very soul. It's the court basically saying, listen, Parliament, you can absolutely amend the Constitution, you can renovate the House, but you cannot knock down its foundation. You cannot destroy its basic structure.
Now, according to Conrad, this kind of destruction can happen in a couple of ways. The first way is pretty obvious. You pass an amendment that directly gets rid of an essential feature, like democracy or the rule of law. But the second way is much sneakier. It's when you use the form of an amendment to do something you were never meant to do. For example, imagine instead of a court deciding an election dispute, Parliament just passes a constitutional amendment declaring candidate X the winner. That's not an amendment. That's a court judgment wearing the disguise of an amendment. It's usurping the power of the judiciary.
Okay, so now let's zoom in on how this very theory was hammered into actual law right in the middle of the intense and hugely important constitutional debates in India.
One of the key concepts you have to understand here is autochthony. It's a bit of a mouthful, but the idea is simple. It means homegrown. It's the idea that the Indian Constitution is legitimate because it was made by the people of India for the people of India. Its authority doesn't come from some British law like the Indian Independence Act. No, it flows directly from the Constituent Assembly, which represented the will of the Indian people. This is what establishes that the ultimate authority, the constituent power, was always Indian.
And this brings us to a huge point of confusion in Indian constitutional law. Article 368, the part that gives Parliament the power to amend, was actually amended to say that Parliament has constitutional power. This caused a massive debate. But in the landmark Keshavananda Bharti case, the Supreme Court basically adopted Conrad's logic. They argued that this is a misreading of the term. The constitutional power that Article 368 talks about is a delegated secondary power to amend. It is absolutely not the original popular power of the people to create a constitution from scratch. Parliament holds the renovator's tools, not the original architect's blueprints.
So in the end, the basic structure doctrine acts as this crucial judicial guardian of the people's original will. But that leaves us with a pretty fascinating final thought, doesn't it? Is this doctrine the final word on the matter, or is it just one chapter in a long, ongoing conversation between the people, the parliament, and the courts about what the true soul of the Constitution really is? Maybe, just maybe, the story of a constitution is never truly finished.